I would now like to introduce our instructor, Tia. We are so happy that she was able to fit us in on her calendar. She is a wealth of knowledge on this topic in the state of Oregon. Tia Politi is of Rental Housing Support Services. She is a rental owner. She's a graduate of the University of Oregon, licensed property manager from 2009 to 2023. And she's president of the Oregon Rental Housing Association, Owners Association for Lane County, both of those. Secretary for the ORHA Education. She's a columnist, I apologize, for Mind Your Business. 2022 Housing Hero for the St. Vincent de Paul of Society of Lane County, and also Landlord Tenant Instructor for Lane ROA statewide, author and instructor for Landlord Bootcamp, and author and instructor for Renting a Home, teaching high school seniors rights, risks, and responsibilities of tenancy. Without further ado, I want to turn it over to Tia.
Hey, everybody. Thanks so much for the warm welcome. I'm sure there's wild applause in the background that I can't hear. I'll just assume that. As an only child, we always assume that everybody loves us. You may not. Please feel free to ask questions as we go through the presentation. I'm going to start to share my screen now, and hopefully I picked the right screen. Screen 1 or screen 2? Let's see. Let's try this one. Share. Yeah. Now, can I drag it over, or am I going to be forever facing away from you? Here, let's do this. I'll just move my camera. All right. And now I can't see myself, so I hope I'm looking at you guys.
Yep.
All right. How does it look for you guys? You good?
Excellent.
All right. We're here today to discuss the legislative update for what happened during our last long legislative session. It was quite the rodeo. My name is Tia Politi, and I'm president of Lane ROA and Oregon Rental Housing Association, and I do a lot of different stuff in the housing industry. My history a little bit, I grew up in poverty. We were always renters, never owned our own home. And when my husband and I married and got our first, our home, it was amazing. And about 15 years later, we refinanced and bought our first rental property. And since then, we're small timers. We only have 4 units, but it's been an amazing way to build financial stability and generational wealth over time. So I strongly recommend it, but only if you know what you're doing. So I was fortunate that when I went into the property management industry, I went to work for a smaller company that taught me how to do everything, right? I got opportunities I wouldn't have gotten. I started with maintenance. I went into office management, doing evictions, and that's one of the best things you can know how to do. But if you don't know what you're doing, you will pay a heavy price. So our legislative support team is headed up by Sean Miller. He's our longtime ORA lobbyist. Your membership dues, if you're a member of one of the chapters of Oregon Rental Housing, go to pay him for his efforts, as well as our ORA legislative director, Jason Miller, and our deputy legislative director, Ben Siemens. We fight for landlord rights to the best of our ability in this blue state. It's sometimes an exercise in frustration, but they keep going. And the pendulum doth swing back and forth, right? And we are seeing a lot of even moderate folks who may be Democrat going, you guys have gone way too far. So, hopefully over time, they make things bad enough that people end up voting differently. We'll see.
Tia?
Yes.
Tia, if you just want to move your camera up a little bit, we're not seeing your face.
Oh, how's that?
Yes, much better.
Now that's too much, right?
No. Nope, you could go a little higher. We're seeing half your head. There you go.
Is that perfect?
Yep, that's
Thanks
perfect.
for letting me know.
No problem.
Okay. We also have an ORA legislative committee, of which I am a part, where we discuss how we're going to vote, what we're going to push for as bills come forth. And that's been really fascinating to learn how the legislative process works. And then we have a subcommittee, which is the rapid response team during these negotiations. Sometimes, our legislative advocates need a fast answer. And so that's where the rapid response team comes in, and we can set up a meeting in no time and guide them in how they want us to approach a specific piece of legislation. The Key PAC is our nonprofit that donates dollars to support legislators who are sympathetic to our cause. And I'll talk more about that later. if you're a member of the Oregon Rental Housing Association through one of our 15 local chapters, you will get alerts from state and local, if you're part of that state and local association, we ask you to write letters, we ask you to testify, we ask you to contact your representatives. It's extraordinarily successful. All right. Our Oregon legislature convened on January 9th of 2023. That's our long session. So every other year we have a long session and then a short session. It's up to 160 calendar days, and the long session happens in odd years. Our last day of any long session is June 25th. And so as we're coming close to that, we're looking at what's happening right up to the end. It can be extended with special sessions, which they had talked about due to the Republican walkout this year. But so far, it wasn't needed because they came back in time to pass the budget. Laws are enacted on the date they're listed if they're an emergency, or they become effective January 1 of the following year. Emergency legislation can be passed once it's passed both houses and the governor signs it. So House Bill 2001, which we'll talk about, was signed on March 29th, I believe, and went into effect immediately. Democrats hold majorities in both houses. Republicans have had limited options, but were able to slow the process. They asked that each bill be read in its entirety, which they can do. The GOP called on Democrats to follow a law that requires bill summaries to be written at an 8th grade reading level. And clearly the legislation I'm reading is not there. I'm not the smartest person on the planet, but I have a college degree and I'm a good reader and writer. And sometimes I am really struggling to interpret these laws as well. We had a boycott that started on May 3rd, arguing that the Democratic leaders had been refusing to follow that legal process for passing bills and were pushing bills that were too extreme. With the Senate quorum lacking, legislative business can't move forward. Most Republicans returned on June 15th within 10 days of what's called sine die, which means that's the end, right? OLIS, the Oregon Legislative Information System, there is a link to OLIS if you want to check it out. This is where you can see the bills in their entirety. You can see how they pass through the legislature, when they become effective. You'll see certain bills that start as, not firm, and then at the end, they're called enrolled once the bill has passed as amended. This gives information on the session, bill and law updates, assigned committees, who's on a certain committee, and reports. So let's get going with the actual bills that passed this session. So Senate Bill 0067 was actually something nice they did for landlords, because landlords were very much abused during COVID. Some landlords faced ruin, had to sell their properties. They relied on that income to support themselves. Some had to refinance just to pay their own bills, while tenants were relieved from paying rent. So this is sort of a little, okay, for you guys who really suffered, we'll give you something now. It creates an income tax credit for lost rental income of the landlord that occurred during the COVID-19 emergency period. It applies to tax years beginning January 1st of 2020 and before January 1st of 2022. It was effective 91 days after sine die. A landlord must be certified by the IRS to receive a credit. So, there is a government process you have to follow. And the IRS is working on rules for certification. I'm not sure where those are at, but we're probably approaching that 91-day mark. So I imagine those will be coming out soon. An excess credit may be carried forward up to 3 tax years. So it's giving us something, which was better than nothing. Childcare and rentals is one of the most controversial bills. Here's the link to the measure if you'd like to check that out. It basically says a landlord may not prohibit a tenant's use of a dwelling as a family childcare. Inspections may not impede the well-being or safety of children. The landlord may require the tenant to pay in advance for any modifications needed by the tenant to run that business to be in accordance with the Office of Child Care. Prohibit it if not allowed under zoning or an association's governing documents. So maybe you have a property in the Avalon Homeowners Association that won't allow it, or some other association. It's possible to push back on that. You can prohibit it if the use is not allowed under the Early Learning Council rules. I've done a great deal of research into this, and one of the things that made me feel a little bit reassured is, wow, only the best and brightest tenants are going to be able to do this. The Office of Child Care is extremely strict. I had no idea the hoops that they make people jump through, including FBI level background checks for care providers. emergency plans, dietary restrictions, sleeping plans, playing plans, transportation, health. I mean, it's really quite extensive. So I felt a little bit better about that. But there are two levels. There's registered family child care homes and there's certified. Registered has a little bit less or less stringent requirements. Certified is over the top. But even with a registered home, they can only care for up to a certain number of children of certain ages, no child under the age of 6 weeks, various things, and they have to just go through an entire litany of hoops to jump through to make this happen and to successfully sustain it. I think a lot of people's concern is excess wear and tear on the property, traffic in the neighborhood, noise, etc. I think, traffic will be a problem as parents pick up and drop off potentially. So, not every neighborhood, not every home is going to be suitable for this type of use. And really, your tenants are going to have to know how to jump through all of those hoops. It does allow the landlord to require a waiver for a liability or a surety or liability policy, adding owners or landlords as additional insured. So we've got an attorney working on the form right now. I've written an article or a draft of an article that we'll be putting out later through the Oregon Rental Housing Association and Lane ROA. So you'll get to see kind of what those are. I also post all my articles on my website, and the address is at the end. So if you're not a member of either and you want to kind of see what I'm writing about, it's there for you for free. So then we're going, okay, is a bond better? Is our liability waiver signed by the parents? I think our consensus is that no, we want that insurance policy, right? And that's going to be another barrier to having a child care home, as that's likely to be quite expensive. The landlord may require at their election either the parents of any children under care at the home to sign a document in which they agree that the landlord, owner, or association is not liable for losses from injuries to their children or their guests, acknowledge the care provider does not maintain liability coverage, or carry and maintain a reasonable surety bond or liability policy covering potential injuries, and names the landlord, the owner, or the association as an additional insured. So if you're a landlord and you can require, renter's insurance of your tenants, you'll probably already know that you can't be listed as an additional insured, only as an interested party. But this is going to say, no, we're an additional insured and we have the right to attach that tenant's policy to pay for any issues that may carry over to the landlord. The caregiver is not required to have insurance unless required by the landlord. And so I think our attorney is going to come back and our form's going to say, hey, we really recommend you require insurance. But I haven't heard yet. He's still working on that. The qualifications, the care home must be certified. Check out these statutes. Go to the Office of Child Care. You'll be as shocked as I am. I mean, I'm not shocked. I think it's smart, right? We're talking about vulnerable children who could easily be abused and are, under the care of virtual strangers. So I was very reassured by what I read online about all the things that they have to do. The tenant has to give notice of the landlord of their intent to run a daycare. They can't just start it up without talking to you first. And I've even gotten, one of the things I do is I've staffed 5 landlord helplines around the state, and I've already gotten landlords saying, hey, my tenant's doing daycare and the bill isn't effective yet. So can I say they have to stop? Yeah, you can, right? It doesn't go into effect until January 1. The landlord must cooperate with this, right? They can't deny it. You got to be careful if you terminate for no cause. It could be construed as discriminatory if the tenant has indicated their intent to run a family child care home. The Office of Child Care is currently writing rules for landlords as to what that's going to look like, what they can and cannot do. I'm trying to get some information on that so that I can add that to my article, obviously, so everybody knows what you can do. The landlord may not retaliate by increasing rent, decreasing services, serving a notice of termination, threatening to bring an action or bringing an action for possession because the tenant wants to run a child care home. Retaliation is covered in 90.385, and basically there's a penalty for that. Everything a landlord does wrong, 385. Everything a landlord does wrong has a financial penalty associated with it. And in the case of retaliation, it's 2 times the monthly rent plus the tenant's actual damages, which of course can include attorney's fees. So you must tread carefully. For rent increases, Senate Bill 611B passed. There's a link to the statute if you'd like to see it. It basically states that a landlord terminating a tenancy with a 30-day notice without cause during the first year of occupancy may not charge rent for the next tenancy in an amount greater than the amount they could have charged the terminated tenancy. And that's very different from what it was. So the law used to be that if we terminated, say you move someone in on a month-to-month agreement and the first few months it's fallen apart, right? We could terminate on a 30-day no cause, and then we were allowed to raise the rent to whatever the statutory rent cap amount was. Now, this has changed it and said, nope, if you terminated then, you're charging the next tenant the same amount you charged the old tenant, right? Because you can only raise rent once a year. And that's a new part of the bill as well. They were trying to get the exemption for new construction down to 3 years, and we successfully lobbied for it to stay at 15 years. What that means is that, if you have a newer building, you can go beyond the rent cap, which is 7% plus the CPI, or 10%, whichever is less. So it limits these increases to no more than once per year, to the lesser of 10% or 7% plus the CPI. The CPI comes out every September, so we don't know yet what the consumer price index will be for 2024. But I'm telling landlords, I bet you it's going to be more than 3%. So if you want to do a 10% increase, you're probably safe to do that. We'll find out. Let's see, it is the 20th. We'll probably find out in 5 or 6 days. And I have a link to that on my website if you'd like to check that out. So if you're planning to raise rent for January, I think it's pretty safe to assume you can do the full 10%, because I can't imagine after this year of all the inflation we've experienced that it'll be any less than 3%. But when we first started, when Senate Bill 608 was passed, our first year it was 7% and the CPI was 2.3%. So we could raise rents 9.3% that year. And the next year, I think it was 9.9, right? Or 9.7. Anyway, that changes every year. So you've got to stay plugged into what your legal limit is. At some point, inflation may moderate and we will be below the 10% cap. I don't think that's a big deal for most landlords, as long as you've kept your rents in the market. If you haven't, that's going to be a bigger challenge for you. It declared an emergency. It was effective on passage. I knew it was coming. So I had one tenant who, she's really one of my favorites. She's been with me since 2005. She's done amazing. I've done a lot of great things for her. She's done a lot of great things for me. She's the only tenant I've ever had in that building, and she's just keeps it clean and takes such good care of stuff. I mean, I bought the woman granite counters, right? Because she went through all the trouble to sand and refinish all of my kitchen cabinets. And, so we have this wonderful relationship. But she was so far below the market. It was just getting ridiculous. So this year I did send her out. I sent out that maximum increase well before the passage. Any questions? Can I keep rolling along?
Yeah, we have 2 questions.
Okay.
Can a landlord raise above 10% for newer houses?
Yes, so that's what it says. Remember, the exemption for new construction remains at 15 years. So you can raise the rent to whatever the market will bear if you have a newer building. You need to be careful, though. Even before Senate Bill 608 passed, a landlord could be found guilty of constructive eviction if they raised rent beyond what beyond what was reasonable for the market. So I'm an eviction specialist as well, and I would have landlords come to me. I would tell them about the costs and the time involved in doing an eviction, and they would say, "Oh, well, I'll just raise their rent $500 a month, and they won't be able to afford to live there." And I said, "Well, unless you can prove to a judge that that is in the market and that your market was under rented by that much, you could be found guilty of constructive eviction." Right? And which is a penalty, I believe, of 2 times the monthly rent, as well as the tenant's actual damages, and they have a defense to an action for possession. So you do need to be careful of that.
Okay. And the next question, I have a client that is allowing tenants to remain in a unit until the end of the lease, then moving them out so she can raise the rent. The home is changing owners, so can she not raise the rent for the new tenants? ?
So that depends on how the tenancy is terminated. If you terminate a tenancy for cause or for one of 4 qualifying landlord reasons, then you are allowed to raise rent for the next tenant to whatever the market will bear. If you're terminating in the first year for no cause, then you can only increase the rent for the next tenant by whatever your statutory rent cap is, if you have one. So if you're a newer building, sure, within the past 15 years, yes, you could raise the rent to the market. So I'd need to know more about your specific situation to know exactly how to give you guidance there.
Okay. Next question. Is the 10% cap rate only in Eugene area? Does the 7% plus
No,
CPI?
this is state law. So what we're
Okay.
talking about here is state law. But since you brought up Eugene, phase 2 went into effect on August 25th, and it's a nightmare. And I'm talking to landlords every day who are like, that's okay. I got good tenants, biding my time. As soon as they give notice and move out, I'm selling and I'm buying somewhere else. No, but again, don't bother the city council with the facts. Their minds are made up. And what they've done is created a disincentive for Eugene landlords. And part of that bill is boggling my mind and the attorney's minds in regards to leases that expire in the first year. But I don't want to go down a rabbit hole on that. So for Eugene and Portland, the rule is if you raise rent to the maximum, so this year that would be 10%, right? So if a landlord sends out a rent increase notice, a 90-day written notice to increase by 10%, then they have to inform the tenant of their right to receive relocation assistance. Portland has set amounts based on number of bedrooms. Eugene is just a flat 2 times the monthly rent. So you don't have to do any of that if you keep your rent increase at 9.9%. Right? Then you're free from that. They were talking about making it as low as 5%, like limiting rent increases to that. And even they realized that would impact development in the area. So
okay. And the second part of the question is, does the 7% plus CPI still apply to Springfield?
Yes, it applies to the state. Okay, the lesser of 10% or 7% plus the CPI. But Springfield's great. Springfield's business friendly. We actually, one of my board members and I went and met with the code compliance people in Springfield, and boy, were we relieved. They were like, hey, we're seeing what other communities are doing, and we're wondering if we should be doing any tenant protections. And, I said, there's parts of what they're doing that I think are important. And as a renter my whole life, and I teach renters, I was never taught how to be a renter or the risks involved with that. And so that's why I teach this class, and I actually offer it free to anybody who wants to teach it in your community. I'm happy to send you my PowerPoint and you can go teach it. You don't get a lot of time, boy, you got to fly through everything in one period of about 50 minutes, and there's a lot there. But I really think it's an essential part of life skills education that we're not giving our children, right? They virtually none of them know what it means to be a renter when they go out, and they end up getting bad history. They end up getting evicted. It's not a good scene.
Okay, we've still got some more questions, so I don't know.
Okay, well, yeah, we kind of need to get through this too. We're almost at halfway through, and I'm not even halfway.
Can a landlord increase the rent within the original term of the lease? For example, a 2-year lease. Okay.
No, you can increase rent within the first year of tenancy, and afterwards you can only increase it annually.
Okay. I have heard you say newer builds twice. What is the definition of a newer build?
There you go. Second line down there, third line. The exemption for new construction remains at 15 years.
Okay. One thing, I don't know if you can do this, but they're asking if you can make the slides larger, and I have no idea about that.
I don't know. Let's see. There's more. Because, yeah, I'm seeing them as like half a page on mine.
They're really small in the center of our page.
Are they really?
But for everybody on the call, we will be sending these out via email.
Here we go. Maybe I can't. No, that didn't. Oh, now that's too big, right? How does that?
Yeah, it doesn't. We can't see the full screen now.
Yeah, me neither. Let's see. So that's not any better, is it? What if I right click here? See all slides, magnify slide? No, that's not good. Huh. I've never done this before, but hey, I'm learning. See, and that goes too big. So how do we do bigger, but not that big? Sorry about that. I'm not sure. I've never had this issue before. Display settings.
Instead of share screen, can you choose like share window, and it lets you click your presentation rather than the full computer screen, and then it may be the other direction.
How about that? Did that help?
Oh, there we go.
Yep.
Did that help? Okay, good. It helped me too. Now I've got to move my camera back over though. So, okay. And you got me in the camera,
why don't
right?
we continue on? And yeah, we've got a lot of questions in the chat, but let's go ahead.
I'm welcome to stay when we're done too.
Okay.
Okay, great. Hey, that works better for me too. Thanks for bringing that up. All right, SB 1013A is a really great change. I mean, that's one of the things that I do applaud Governor Kotek for, even though I disagree with her about almost everything. This is one thing that I'm really happy that she's doing. Is she's, part of House Bill 2001 was we need to make more housing. We need to provide more housing options. And certainly we experienced that during the Holiday Farm and Beachy Creek and all those terrible fires of 2020. People needed some place to live. And so a lot of the cities waived their restrictions against having someone have an RV, somebody living in an RV on their property. And now this is codified in law. It does permit rural homeowners only to cite one recreational vehicle on their property. And I think this is great. We need more of these types of options. It passed the House and Senate. It's effective at the beginning of next year. And counties are currently working on rules for that. SB 1069B is something that I think was presented as a gift to landlords, but we don't see it as such. It basically allows, part of it is okay, but it basically allows for electronic notices and electronic payments. So currently, if you refund a security deposit to a tenant, you have to refund it either by first-class mail or personal delivery. This would allow the tenant to agree to accept an electronic transfer of money to their bank account or by Venmo or Zelle or PayPal or something else. And it allows a residential landlord and tenant to agree to provide written notices by email and mail. We're concerned about that because we already have landlords who mess up service of notice by posting and mailing when they don't have the right. And we're just concerned that this is going to lead more landlords down a bad path of not knowing how to serve a legal notice. And so Aura is talking about some options, the options that we're considering, and we're going to vote on at our next meeting in November, is either adding this option to our notices, but that is going to cost us a god awful ton of money for all of our forms. But one of the other options we were talking about is how about we just have one box for first class mail, which is how all the attorneys recommend you serve notice, and we do too, and one box for other, and then put the statute as allowed by. So if somebody knows what they're doing and knows how to serve notice by post and mail or email and mail, they can do it that way, right? But I think it's going to save, that's kind of what I'm going to be voting for, but I don't always get my way. So we'll see how that goes. But to us, it just provides one more opportunity for a landlord to mess up and have an attorney, tenant attorney, give them an expensive lesson in court. This is the better part of it, which is allowing us to refund money by electronic means. But it must be allowed under a signed written agreement executed after the tenancy has begun and the tenant has taken possession of the unit. So you can't make it a requirement of tenancy. For notices, the agreement specifies the email address at which a landlord agrees to receive email messages as written notice from the tenant and the email addresses for the tenants. For electronic payments, the agreement specifies that the landlord may return any amount due under this subsection electronically to a bank account or other financial institution designated by the tenant. For email and mail notices, the agreement specifies the email address from which the landlord agrees to send and at which the landlord agrees to receive email, specifies the email address from which the tenant agrees to send and receive, is executed by both parties after the tenancy begins and the tenant has occupied the property, and allows the landlord or the tenant to terminate email notices or to change their specified email address for receipt of written notice by giving no less than 3 days written notice, and includes notice in substantially the form listed in ORS 90.155, which is how to serve notice. It's one of 3 parts of how you serve legal notice. We don't think it's that great, except maybe for refunding security deposits. Senate Bill 5536A limits expenditures by the Oregon Real Estate Agency. The amount of $14 million and change is established for the biennium. That's the maximum limit for payment of expenses from fees, monies, or other revenues, including miscellaneous receipts, but excluding lottery funds and federal funds collected or received by the real estate agency. Oh, and I made a mistake. Oh, wait, no, it was effective July 1 of 2023. So this was one of the budget measures they had to come back and vote on. House Bill 2001 was the real big change we had, and that went into effect immediately. It was revised and amended more than 10 times, 74 pages long. The part that affects landlords is like one part of this massive, thing that the governor wanted. It included many parts of other pending bills. It was an emergency passage thing. So, everything's an emergency now. No time to prepare, no time to change our forms, no time to educate. It happens now. signed by the governor on March 29th. It created a housing needs analysis, housing acceleration, which we do support as well, support for homeless children, $80 million for rent assistance, which has been great. I think that was one of the better things that came out of COVID. How many people have I evicted because, you know, that could have stayed in their homes because they just suffered a short-term problem, right? And 2 or 3 months rent could have made all the difference. So we are seeing that, and that's been really great. The requirements, it requires residential landlords to extend notice periods for termination of tenancy, for non-payment of rent, and to include additional notice to the tenant. We can't do a 72 or 144-hour notice for non-payment anymore, except in a week-to-week agreement where it is still allowed. It requires landlords and the court clerks to include rent assistance information notice with summons for non-payment of rent and with your complaint based on non-payment of rent. It postpones the date. So part of what they did was, okay, we've got rent assistance, but it takes time. It doesn't happen overnight. So how can we extend the process as long as possible to make sure it happens? When this bill first came up, they wanted to do what COVID did, which is if you apply for rent assistance, oh, sorry, landlord, you have to wait 60 days is what they wanted to do. And we were like, no, and heck no. We have been through the ringer for the past 3 years. You can't make us keep doing this. And so we were able to successfully remove that part of the bill. We knew this was coming. We knew they would want it because this is what they did during COVID. So it postpones the dates for first appearance and trials for eviction based on such termination notices. So now instead of getting to court, you know, in 7 or 8 days, you're getting to court within 15 days. And then if the tenant asks for a trial, instead of that trial happening within 2 to 14 days, it now is happening 15 to 30 days out. This is all designed to give the tenants more time to apply for rent assistance and more time for the rent assistance agencies to come through. It requires at court now, I have a special form I have to fill out and provide, or I have to swear under penalty of perjury. The landlord must attest that the tenant who is absent at a first appearance remains in possession of the premises before the court will issue a default judgment. The judges are also looking over notices each morning to make sure they comply with the law, and they will dismiss any matter that doesn't comply with the terms. It requires public bodies and grantees to inform tenants and landlords regarding rental assistance applications. Requires the courts to annually set aside and seal certain inoperative residential eviction judgments. And there's more language that does not directly affect landlords. It includes, so what's non-payment? Well, it's not just rent. It includes rent, late charges, utility or service charges, and any other charge or fee described in a written rental agreement. It does not include tenant owed payments for damages to the premises. So if you have a tenant who's done damage and you have a tenant who owes you maybe, 5 months of late fees, put those on separate notices, because the damage notice isn't subject to any of these requirements. You'll get to court faster, and they either pay by the deadline on the notice, or you don't have to accept rent after that. That used to be one of the best things we had, right? If they didn't pay by the time the notice expired, we could say we don't have to accept it. Well, now we do. And that was kind of a bummer. I'm on a horrible merry-go-round with several owners whose tenants keep doing this. They don't pay. We serve notice. We file an eviction in court. They pay, at trial. And by that time, we filed another eviction. So we're on a second eviction that's almost simultaneous with the first one, or overlapping it. And then we're right back a couple of months later. So it's been, if they thought this was going to reduce evictions in the state, they were sorely mistaken. My eviction business has jumped almost double since this bill passed. It requires the landlord to deliver a copy of the notice posted on the Justice Department website, which is, hey, here's where to go get rental assistance. You have to serve it with a notice of non-payment, and with a notice for non-payment of rent, we now have an extended time frame, the 10 or 13-day notice for non-payment, or a notice of termination with cause if it lists unpaid rent and late charges, etc. So for those of you who aren't educated about such things, a for-cause notice can be used for violations of the rental agreement, and it's also the way you collect money other than rent from a tenant who owes money, right, for late fees or damages to the premises, etc. Any summons for a complaint of possession based on non-payment must include the special form, and the eviction can take up to 2 months if the eviction goes to trial. And you may have to issue subsequent non-payment notices before the first notice comes to court, which was what we do. I'm telling all of my owners, you file that notice, you serve that notice, you file in court as soon as you can. And what we're seeing are the rent assistance agencies are paying those court costs. If the court will dismiss a complaint if the landlord fails to deliver the required notice, if the landlord caused the tenant to not tender rent, including not reasonably participating with a rent assistance program. So you must cooperate, you must participate. Yes, you have to give them a W-9. Yes, you have to do all of these things. You can't refuse to participate or your tenant just gets to live there for free. Or the tenant paid the amount owed, had rent assistance pay it, or other payment came through to cure the notice. And they only have to cure the notice, right? So if there's another notice after that, you got to file a new case. But typically what we're seeing is rent assistance agencies that are going to pay not only, they're going to pay everything that's owed going back if the tenant qualifies, and maybe even a month or so going forward. If payment was tendered after the action was commenced, then the tenant is not entitled to a prevailing party fee, costs, or attorney's fees, which typically they could ask for in a dismissed eviction. And the landlord may charge the tenant for their filing fees if the tenant pays after the notice is terminated. It requires an updated notice on the website. They translate it into Spanish, Korean, Russian, Vietnamese, and Chinese. It displays links to the English version and translated forms. And for rent assistance agencies, they're required to promptly provide a dated application receipt to the tenant to show the landlord. But a lot of landlords are like, in fact, one of my own clients, we served a 10-day notice and he's calling me today going, well, they applied for rent assistance. I'm like, we've just wasted 11 days. We could have filed 11 days ago. Well, I thought I had to wait. No, you don't have to wait, right? And just because they apply doesn't mean they're going to get approved, right? And what I'm experiencing is that the rent assistance agencies will move forward much more quickly if they know the tenant's under threat of eviction. So don't wait, go for it. They must close an application if the provider reasonably determines the tenant is no longer participating. We experienced that a lot during COVID, right? We'd hear these rent assistance agencies and landlord would follow up and it's like, well, the tenant won't get back to us. The tenant is, is just not responding at all. If a payment is made to a person other than the landlord, they must provide a dated electronic notice of payment to the landlord. I don't know how that would happen. Haven't seen that one yet. For non-payment notices, again, it changed the 72-hour notice to a 10-day notice, changed the 144-hour notice to a 13-day written notice of non-payment of rent. So you can always serve a 13-day notice as early as the 5th day of the rental period for which rent remains unpaid, and a 10-day notice as early as the 8th day of the rental period for which rent remains unpaid. First appearance in court, if it's for damages or some other reason other than non-payment, then you're getting to court 7 days after the judicial day following payment of the filing fee. If for non-payment, it's 15 to 30 days, as I said, and it's delayed. It can be delayed more if a judge is not available, or it can accommodate dates that the plaintiff is not available. The clerk must include a copy of the required notice. So it's interesting, you've got a summons that has the rent assistance notice on it and the complaint as well. So it's twice, has to be in that filing. One of my own clients hired someone else to file a notice I had served, and the person who filed forgot to include it in the complaint part of the eviction, and the case was dismissed. You'll get a default judgment if the plaintiff appears, but the defendant does not. But the judge is going to determine whether the complaint is valid. So in the past, I've seen landlords get some really funky notices by the court, right? Or serve something themselves, or do some improper thing. But if the tenant doesn't challenge it, they got away with it. No more. Now judges, before they even come into court, are looking at every complaint that comes in, making sure, looking to see whether the complaint complies with statute or not. And if it doesn't, it's automatically dismissed. The plaintiff also has to testify or assert under penalty of perjury that they believe the tenant has not delivered possession and that they remain in possession of the dwelling unit. Because, and I understand that, because all an eviction decides is who's entitled to legal possession of a dwelling unit. It does, and who's going to pay the court costs. It doesn't decide anything else. So, if the tenants moved out, the case is resolved. And that was another really big benefit for tenants. We used to be able to get judgment anyway, or we could get judgment for costs. Not anymore. The plaintiff must testify under oath or submit an affidavit that they're still in possession, or give a declaration to that effect. And it's under penalty of perjury. If both parties appear, the parties can agree to a stipulated agreement. Or if no settlement is reached in a non-payment case, then the trial is set out no earlier than 15 days and no later than 30 days. Again, this is designed to give the tenant, the rent assistance places, time to get the rent assistance to the landlord. But if it isn't paid by then, and that's what I'm telling my tenants, heck with this stipulated agreement thing. We just go for trial. They either pay by trial or we get them out. I'm tired of playing these games with stipulated agreements. It also will be sealing eviction records. The first review will be on or before December 31st of next year. Annually, they're going to enter orders setting aside judgments and sealing court records regarding possession if the judgment does not contain a money award or the award has expired, been satisfied, or discharged. So if the tenant pays the award and you file a satisfaction with the court, they're going to seal that if 5 years have passed, right? So you may know that we're not allowed to consider dismissed evictions against a tenant or evictions that are more than 5 years old, but we can still get a reference from that landlord. If the judgment was a stipulation of the parties and it was at least 12 months old from the date of judgment and nobody's filed an affidavit of noncompliance, they'll seal that as well. All right. Did you want to divert a little bit to, I know that's probably one of the biggest bills and one of the bigger questions coming through. Do we want to?
I mean, there's 11 questions in the, and some of them you may have answered throughout it. So are the rules the same for land leases and home rentals?
I don't know what you mean by a home rental or a land lease. If it's a residential tenancy, yes, you're under this. If it's commercial, or isn't about residential living, right? If you're leasing land to somebody to farm it, no, I don't believe this applies. That's a commercial agreement, right? And I know just enough about commercial rentals to be dangerous. What I do know is it's governed by contract law. It's governed by the contract. Whatever the contract says is what you can do. So better have a really good contract. Pay an attorney to draw you up a good one.
If you move a tenant out based on allowable remodel, do you have to offer the rental back to the same tenant and cannot raise the rent?
No to both. That
Okay.
was actually something that was in Senate Bill 608 that we successfully removed. They wanted to give them the right of return.
Okay, if a lease is expiring and the tenant wants to stay, can the landlord give 90 days notice prior to the end of the lease and make the tenant vacate?
Well, actually, it depends on when the lease began. If you had a lease of less than a year, except in Eugene or Portland, then you can do a 30-day notice of non-renewal. If the lease was for more than a year, then you can only terminate for cause or for one of the 4 qualifying landlord reasons. If neither party takes action, the lease automatically converts to a month-to-month upon its expiration.
Is there any group thinking of seeking legal action against Eugene City Council over these new restrictions?
Yes, I'll be talking to Deborah Emsey of Multifamily Northwest next week. She's on vacation this week. But honestly, I just think we'll be dashing ourselves against the rocks, right? I mean, Portland got sued and part of theirs was undone. Eugene learned from that. I think they also learned from their attempt to make screening fees $10. But I don't know. We'll see. I don't know enough about how to do that. In fact, my idea is, what I'd like to see is, could we please find a legislator to sponsor a bill that would say no more local overlays, state law only, because that's what's killing us. Trying to, as a rental landlord agency, we're trying to figure out, do we have to do specific forms like for all of these different regions, Ashland, Bend, and how are we supposed to do that? It's crazy. It's absolutely crazy. And that's what I'd like to see. But, I don't know how successful that would be in our current makeup of our legislature.
Okay. Once a 1 year term is up and the tenant wants to stay on month to month, can terms be changed from original lease? Say a dog has been destroying a yard, to terms to no dog allowed.
Well, certainly if the tenant, that's a long question. I'm not sure where we're at with time.
Yeah.
That's a long question and it has some various answers, because yes, landlords can change certain rules, but if you have an animal destroying a property, then the cure is you fix the damage, right? So you serve a 4-cause notice to the tenant, fix this yard, and if you can't stop the dog from damaging it, you get rid of the dog. So, I prefer 4-cause, and I think eventually we're going to do away with no cause. We have to face that, and my business is already hopping because 4-cause notices are more challenging to write up, but that's how you handle that. You don't let that happen. And I'll tell you what, this is a side note, but COVID made landlords lazy about inspections, right? and tenants wouldn't let them in and all these different things. Well, that's, these damage doesn't usually happen overnight. It happens over time. Hoarding doesn't happen overnight. It happens over time. So you can't be a lazy landlord. You got to get in there and inspect at least once a year, twice a year or more if you feel there's a problem, right? You drive by and you see, the blinds are askew and the yard isn't mowed and there's stacks of tires. You better get in there and inspect.
Okay, I think if you want to go ahead and then we'll,
Sure.
we've got 5 more
and
questions.
I can stay a little after.
Yeah.
Okay. So House Bill 2468B authorizes the Early Learning Council to develop those rules I was telling you about the childcare, so that we can fly by. RV parks, it defines a recreational, this is House Bill 2634A, defines an RV park for the purposes of residential tenancy law. And this is kind of just clarifying that if someone is staying in your RV park as a vacation, then they aren't subject to ORS 90. Right, it's a vacation rental. And if you look at the definitions in ORS 90 about what constitutes a vacation rental, it's different than this, right? The period of authorized occupancy doesn't exceed 90 days, but it's similar in that the occupant rents the unit for vacation purposes and they actually have a primary residence somewhere else. 2680A does impact landlords. It's regarding screening charges. It is now requiring a landlord that after they screen someone and if they've used a tenant screening company, or maybe they apply or have an account with Experian or TransUnion, then they must provide the applicant with confirmation of the screening, including a copy of a receipt from the company or agency. And we must disclose their right to a refund of the screening charge if, I don't get that sentence. If there's no unit that will be available at a reasonable future time. I didn't write all this, so I'm not understanding that sentence myself. It does, if you do require an applicant screening charge, you must refund the charge to the applicant within 30 days. If you fill the unit before screening, you don't screen the applicant for any reason, you've not conducted or ordered any screening of the applicant before the applicant withdraws the application in writing, so you're allowed to do that. The tenant can say, hey, I found something else, I want my fee back. An applicant cannot recover a charge from the landlord if they refuse an offer to rent, but they may recover from the landlord twice the amount of any applicant screening charge paid, plus $250 if the landlord fails to comply, which isn't, doesn't break the bank. It went up from $150 now to $250. House Bill 3042A puts limits on public housing. It limits terminations and rent increases for 3 years after tenants' housing is withdrawn from publicly supported housing. So I used to work in public and affordable housing for Homes for Good here for a couple of years. And there's these projects like project properties, Section 8 project properties, where a private landlord will put it under the auspices of a Section 8 and be obligated to these HUD things to receive HUD ruling. And usually those are required to stay in place for like 30 years. And then at some point they can withdraw it and make it market rate housing. So this is just clarifying that, hey, for those landlords who do that, which is a very small number, the landlord may not raise rent for 3 years following that. They must notify the tenant, and it applies only to residential tenancies. They must notify those that existed on the termination date, and does not include any tenants not in publicly supported housing and who receive Section 8 vouchers, essentially. So if you have a property and you're renting to a Section 8 voucher holder, this doesn't apply to you. Okay, this applies to project-based Section 8. House Bill 3151A impacted manufactured housing parks. It limits improvements landlords may require of tenants. Sometimes the parks went a little wild and you've got to put up this and it's got to look like that. And a landlord may not require as part of the improvements under the rental agreement that a tenant pay any fee to the landlord for improvements, pay any systems development charges, construct or repair an improvement that cannot be reasonably removed and owned by the tenant at the termination of the tenancy, except for things like porches, stairs, decks, awnings, carports, sheds, or vegetative landscaping, right? Or any other improvements necessary for the safe and lawful installation of the manufactured dwelling. So the parks were going a little crazy and making tenants do stuff. House Bill 3309B talks about accessibility improvements, and it directs Housing and Community Services to provide a report to the appropriate interim committee of a legislative assembly on the department's financial support of dwelling units with certain accessibility features. So, there's a big push. There's a really high demand and low supply of housing that can accommodate disabled people in wheelchairs, right? So that's why Eugene, Portland started it. Eugene has as well. Any unit that meets the needs of someone that is defined as accessible under the law must prioritize disabled people for that unit. And I think that makes sense. I wasn't opposed to that. In fact, my husband and I, as we're working on the house we call the money pit, we're looking at making the entire lower level wheelchair accessible, right? I think that's if you're remodeling anyway, why not? It definitely will make it so that you can potentially get higher rent. It's much harder for people like that to find housing. So I think that's great, and I think we're going to see more of this type of thing as we move forward. In fact, I'm kind of expecting that developers are going to have to in the future at some point, not yet, but someday, have to make, if you're building an apartment complex, you've got to make a certain number of those units accessible to people with mobility disorders. House Bill 3417A, this is kind of a good one for landlords. It expands the landlord guarantee program that normally was associated with Section 8 tenancies, or VASH, to include landlords providing housing to tenants who have received rental assistance under specified rehousing initiatives. Currently, it is just for those on HUD housing vouchers. It was an emergency passage, but we do anticipate they're going to be adding different things. If you notice, like, we have so many, there's just been an explosion of subsidy programs around the state, right? Counties, Lane County has its own subsidy program, Shelter Care, St. Vincent de Paul, Catholic Community Services. They're all trying to take advantage of this HUD money and provide subsidized housing. So I think what they're looking to do is add some of those peripheral programs that we're not used to into this program. And this was the best thing we got out of the Housing Choice Act when it was passed back in 2014, was a $5,000 landlord mitigation fund, right? So it would pay for qualifying damages up to $5,000 for a landlord who rented to a Section 8 tenant and suffered losses. Because when they forced us to take them, our argument was, but they're poor. What can we get if they damage our property? So this is just an expansion of that program, and I think that was a nice thing for them to do for us. Certainly, we didn't oppose it. House Bill 3443A now includes bias crimes to the domestic violence section of ORS 90. It will prohibit the landlord from discriminating against applicants or terminating their lease or taking other specified actions due to their status as a victim of a bias crime. It provides that a tenant who is a bias crime victim is not responsible for damages resulting from the commission of bias crimes, which is exactly what it is for domestic violence, sexual assault, or stalking. So it's basically taking what we already know about our domestic violence laws under ORS 90 and expanding them to include bias crimes, right? It provides, just like a victim of DV can, with proper verification, they can terminate a lease or a tenancy with 14 days written notice, and you can't charge a lease break fee. Bias crime victims are going to be included in that. The bill has 6 other sections that amend other statutes, but that's basically the way you can wrap your mind around it. It just makes them just like a victim of DV. A bias incident means a person's hostile expression of animus toward another person relating to the other person's perceived race, color, religion, gender identity, sexual orientation, disability, or national origin, of which criminal investigation or prosecution is impossible or inappropriate. Bias incident, so you've got a Jewish tenant and somebody comes and spray paints a swastika on their door. Well, you're not going to be able to hold them liable for the damage, and you're going to have to release them if they want to be released, right? A bias incident does not include any incident in which probable cause of the commission of a crime is established by the investigating law enforcement officer. So that will be effective on January 1st of next year. House Bill 5019A created funds from housing. It appropriated money from the general fund to specified state agencies for certain purposes related to housing. It limits certain biennial expenditures by the specified state agencies for certain purposes related to housing. It modifies the general fund appropriations, and it was declared an emergency effective July 1 of this year. So nearly 3,000 bills were brought to the floor. Most of them died in committee, but we're likely to see them in the future. I predict that probably within the next 5 years, there will be no more no cause. So I keep saying we're going to have to not be lazy landlords, and we're going to have to learn how to do for-cause notices and how to hold residents liable for their behavior. The Oregon Rental Housing Key Pack. There is a link to our webpage. We help support legislators who support landlords by providing them with campaign contributions. Any contribution is helpful. you can, if you as an individual want to donate $50 or as a couple donate $100 if you file jointly, that is a dollar for dollar tax write-off. It is free money. I even tell people I will pay for your envelope and stamp if you will mail us a check, or you can donate online, I believe, using a credit card. You know, we're doing the best we can. We're fighting the good fight. We're gonna, you know, hopefully we're not gonna go down, but if we do, we're going down swinging. We're trying our best, you know, but it's really tough with the Democrat majority. Thank goodness they don't have a super majority. So they had to talk to us this year, right? That's what we were afraid of, because we lost an important seat, but we gained 2 others. And that made it more balanced, where they don't have a super majority. They can't just do whatever they want. They had to negotiate with us. So, you know, I don't lean either way. I'm somewhere in the middle, and I think a lot of us are. But, you know, if we don't change the makeup of the legislature, we're just going to see more of the same. So what can you do? You can contribute to the Key Pack. You can write letters to your legislators and key committee chairs when we send out that e-blast. Help us. You can testify at hearings. I've done it. It's pretty easy. And if you don't feel comfortable on camera, hey, just write a letter. They'll read it. They'll get it in there. You can speak to your fellow supporters about doing these things above. This all helps, right? And vote, right? We need to vote differently. If we don't, it's just going to be more of the same. All right. Thank you so much for being here with me today. There's my contact information. If you're a member of one of the 5 associations I do helpline for and you have any questions, call me. Otherwise, I do charge for consultation. My current rates are $130 an hour. So I do have my own bills to pay, including my own insurance, and I'm self-employed. So I hope you understand. I want you to pay attention to my email address, because on my website, I give you a ton of free information. One of the best pieces of work I've done for realtors is an article I wrote called Overcoming Barriers to Selling a Tenant Occupied Property. I am still hearing almost daily, you know, certainly weekly, about realtors who just, you know, they're writing up offers where they're saying, well, we require that the landlord remove the tenant before closing. And in many cases, that's not possible. Okay, so read that article. It'll really help you wrap your mind around what you can and can't do when you're selling a tenant occupied property. However, I have not updated it yet to include the Eugene rules. So understand that. I'm hopefully going to be redoing that soon, so that the Eugene rules will also be part of that. All right. Can I stop sharing now?
Yes.
Okay, fantastic. And then I'm happy to answer any questions.
Yeah, we do have some questions in the Q&A. So the first one is, can a rental agreement be written to override tenants' rights in an explicit agreement?
No. Even with their written consent, a tenant cannot waive their rights under landlord-tenant law.
Okay. Just so we are clear, can I file a second eviction case against the same tenant for the same address, even if I have one pending that has not yet been decided, both
Yes.
non-payment of rent?
Yes. In fact, I had an interesting story. I had 2 evictions going against one tenant. The trial date was set the day before the first appearance of the second case. She didn't show up at trial. So we got a default judgment. She didn't show up at the first. Well, no, did she show up at the first? Oh, no, that wasn't it. Okay, it was that our writ of execution. So the last part of an eviction is a writ of execution, where you hire the sheriff to literally forcibly drag them out. That writ was executed the day before her next first appearance. And she was like, but I've applied, but this, but that. And she got drug out. And then we heard from Lane County Rent Assistance paid everything. And the owner was like, I'm taking the money. So, but they paid all my costs. I mean, the first eviction was over $1,300. The second one was a few hundred, plus all her back rent, all her late fees, everything. And the owner was like, yeah, I'm going to take the money and we're just going to stay on it a little better, right? But that can happen. So they let her back in.
Okay. Are all these rules the same for 1 through 4 property investors?
Yes.
Or
yes, there's
just
no
for
exemption if you're a small time landlord.
or just, okay. Or just for those. Okay. Please remind us of the owner qualifying no cause notice reasons.
So you have 4 reasons. 1, the landlord intends to demolish the unit or convert it to a different use other than residential use within a reasonable time. 2, the landlord or a member of the landlord's immediate family intends to occupy the unit as their primary residence. 3, you're going to renovate the unit, and the renovation will render the unit unsafe or unfit to occupy. 4, you're selling the property to a buyer who intends in good faith to occupy the unit as their primary residence. So you've got to have an accepted offer. I've done a lot of those notices. Some of them in those offers, I see that it is an owner-occ loan. Others I don't. So I'm telling the buyer's agent, I need you to execute an addendum that says that the buyer is going to be occupying as their primary residence. You must provide a copy of the accepted offer to the tenant along with the notice. And if you have an ownership interest in more than 4 residential rental units in Oregon, you must pay the tenant 1 month's rent at the time the notice is served. Regardless, it can't be issued as a credit, regardless of what they may owe you. You must pay them, or your notice will be materially defective. In the case of a renovation, I have a lot of people wanting to, well, carpet and paint. Be honest, people, how much work have we done with tenants in place? A lot when we wanted to keep the tenant, right? So it's got to rise to a really high level. I'm not an attorney, but the attorneys I've talked to have said you better be impacting habitability. So I've done 2 of these. One for a property we sold where we had dug a new well. We needed to hook up the unit to a new well. We were tearing out a wall. We had a bunch of wiring stuff to do. I mean, it was major. It wasn't just cosmetic. And that's what you need to think about. In another case, we terminated a tenancy because we had to tear out the bathroom and rebuild it, right? You can't have a habitable unit without a bathroom. So you've got to rise to a pretty high level unless you want to try to be the test case. We don't know yet. We have no case law on where that is. So I have realtors peppering me. Well, what about replacing windows? I've replaced windows with tenants in place. What about the roof? Easy peasy with tenants in place. What about, kitchen counters? I've done that with tenants in place, right? So you've got to really, assess what it is. One of the easiest ways to meet that criteria is if you have an older home that has popcorn texture on the ceiling, right? Doesn't break the bank, but it's hazardous material, usually contains asbestos. And I think for that, you could pretty much get away with it in addition to doing some cosmetic stuff because you're dealing with hazardous materials, right? If you have an older home built before 1978 and it has substantial rot or peeling paint, I mean, you've got to be lead-based certified. And that in that case, right, that may qualify. It's so individual. It's really hard to give generalities, but that's the one that I see a lot of people messing up. Or I'll get the call of, well, how long does my son have to live there? It's like, well, you want the safest answer, 1 year from the day you regain possession of the unit, because that's your statute of limitations.
Can you please detail any new rent assistance programs?
Not really, because there's a million of them, right? So the state, right, OHCS got this $80 million pot of money, and it's distributing those funds. Like around here, I know who the agencies are: Lane County, Catholic Community Services, Community Sharing of Cottage Grove. I've got, but then there's, there's domestic violence housing grants. There's like so many. That's why it basically tells the tenant, call 211. Because, we need to find out kind of who you are, what you need, and what you might qualify for.
And the last question we have here is, does Eugene still accept 4 qualifying landlord reasons?
Yes, but you'll have to pay the tenant 2 months rent at the 45-day mark after serving that notice. And let's say you're an owner who has 5 or more units in Oregon. So you can reduce the amount of the Eugene fee by the amount of the state fee, but the state fee is due at the time you serve the notice. The Eugene fee is due within 45 days. And you've got to give the tenant now a form telling them what their rights are in regards to the notice. The one thing Eugene did for us is stated that if the tenant has received a relocation fee and has not moved out, that they owe the fee back to the landlord immediately. So that's kind of good.
Well, I want to thank everybody for joining us. And Tia, thank you so much for all your knowledge. We will be sending out, like I had mentioned, we'll be sending out the PowerPoint as well as a link to the recording. And also Tia's contact information and her website. So I think that's, it looks like, I don't know, you have one more question in the question answer. So my current situation is I have a COR, Central Oregon ROA Farms lease with a mutually agreed termination on 9/30. Tenant is past due on August and September rent, 10-day notice and pay, 10-day notice to pay or to
vacate. Yeah.
Yes, thank you. Was issued on 9/17. What steps should I take taking to brace for 9/27 removal?
Well, it depends on how you served that notice. If you served it on 9/17 and it expires on 9/27, I'm assuming you served it personally. But I get a lot of calls. People say, yes, I personally served a notice. And I say, so you handed it to the tenant? And they go, well, no, the tenant didn't come to the door, so I taped it on the door. That's not personal service. So just on the top of it, your notice may be materially defective or have imperfect service. I see landlords just not knowing how to serve notice, right? It is one of the biggest reasons landlords lose in court, and a tenant attorney would be only too happy to educate you for an exorbitant fee. So call me, call Cora. You know, they have a helpline. Remember, Michelle Bunting, I believe, runs their helpline, and she can give you guidance. Right? Every situation is so specific. And at the first part of your question, I didn't quite understand how you had a mutually agreed termination date of 9/30. If that was established at the beginning of the lease, that agreement would be construed as unconscionable according to my attorney. I actually asked that to try to get around the law. I'm like, my mind's always working trying to figure out how we can get around these things. And I went to my attorney right when that passed. And I said, so what if you made termination a condition of entering into the rental agreement? And he said, yeah, that'd be unconscionable. Now, does the tenant know that? Will they litigate over it? Probably not. Tenants don't know what they don't know, but that concerned me. My alarm went off when you said that. So thank you so much for having me, folks. And if you don't belong to a local chapter of the Oregon Rental Housing Association, you absolutely should. We send out tons of information that you need to know. We're here to try to keep you safe. We are a nonprofit dedicated. We're volunteering our hearts out, right, to keep you safe, to help you run an effective, successful business. Like any business, you have to know the rules of your business. And you just can't be a lazy landlord anymore. Inspect, act. If you don't know how to do notices, hire me or hire someone else who knows how to do this for you. Learn how to do it. In fact, I'm teaching a webinar through Lane County on October 12th called Tenant Noncompliance and Tenancy Termination. I'll take you through every type of termination you can do, when to serve it, how to fill it out, and hopefully you'll walk away from that knowing how to be a confident landlord and address issues with your renters. It's one of the best skills I ever learned in property management. So thanks so much for having me today, everyone. All right.
So much.
Bye.